Brand collaborations are now a central part of how businesses market their products and how creators build successful careers. But despite the money, visibility, and reputational risk involved, many of these collaborations are still governed by contracts that are rushed, vague, or treated as an afterthought. This episode is about the legal risk that sits beneath influencer marketing, risks that creators, brands, agencies, and even lawyers sometimes underestimate until something goes wrong. We unpack where these agreements most commonly fail and how those risks can be managed before content even goes live. Today, I'm joined by Mary-Grace Olu, a financial regulation associate and a beauty and brains content creator on TikTok. Mary-Grace is a highly accomplished individual who's received numerous accolades and recognitions, including being one of the top UK under 25 most influential people of African descent, Legal Cheek's Best Use of Social Media 2024 recipient, and also recipient of the Top 10 Black Undergraduate of the Year Award in 2022. She's also an LSE LLB law graduate. Her work has been recognized by multiple prominent media outlets, such as Refinery29, Channel 4, and The Guardian. She's also partnered with several big names, such as Student Beans, Unidays, eBay, giffgaff, Tinder, Bumble, and was winner of the 2023 McCann London Women's Association Cannes Challenge, an all-expenses-paid trip to Cannes Lions International Festival of Creativity. She's passionate about bridging the gap between corporations and Gen Z through content creation and law, making corporate fun again. She's an inspiration to many, including myself, and continues to make waves in education, careers, and the beauty industry. Mary-Grace advises on complex financial matters for a range of global clients, whilst also navigating the creator economy from the other side. Mary-Grace advises on complex financial matters for global clients, whilst also navigating the creator economy from the other side of the table as a creator herself. That dual perspective gives her a rare insight into where creator contracts break down in practice and why legal risk often goes unnoticed until something goes wrong. Mary-Grace, thank you so much for being a guest on the ground floor today.
Thank you for having me.
And I'm really looking forward to this conversation because I think it's rare that you get someone in your position that's actually seen both from the client advisory side, but also as a creator yourself. And I'm sure you're going to be dropping lots of gems for people today. So I thought what we'll do before we actually get into legal risk, that it's worth grounding the conversation in sort of the reality and the lay of the land of how these types of arrangements work. So when it comes to brand and influencer collaborations, let's talk about how they're often typically structured. So they are, I know that you can have campaign specific collaborations. So that will be, for a specific set of posts or specific campaign. But you can also have wider, maybe brand ambassadorships where you're maybe working with a brand, maybe with less prescriptive deliverables, but there is an association of your brand with their brand over a period of time. So for people who are maybe new to this area, maybe they're used to your standard B2B contracts or B2C contracts. What's different about the way brand and influencer collaborations get structured?
Firstly, thank you for having me. It's really exciting to be talking about this. I've never been on a podcast talking about this, so it's really interesting. I would say in terms of how these contracts differ, and maybe they've gotten a bit more sophisticated nowadays, but I would say, as you kind of alluded to earlier, just how informal they are. So a lot of the time, the contract isn't your typical, these are the terms set out, this is when you're going to get paid. It's not usually like that. Usually the contract's just pretty much like creative briefs. And then within that, you just agree to it. So they kind of set out the terms, maybe in like a table format. So on one side, it will be like payments, deliverables, brands, things you shouldn't.
Let's talk about deliverables, because I think for people outside of this space, they may not know what we mean by that. So deliverables are, the hints in the name, the things that you need to deliver. And would you say in your experience, these things are quite explicit and clearly defined? Or is there often a bit of vagueness or a risk of vagueness around what is a deliverable?
Yes, I think there's definitely a lot of vagueness, because sometimes a brand might come to you specifically like, we want you to be on this campaign and create a 15-second video to promote this new product. But what that actually looks like in reality is different, because the level of creative control that brands give you really varies. So I would say it's not always very clear, and then we'll get into this later, I'm sure. But then when you've actually created that video or created that concept for them to approve, I think that's where the real issues start to arise in that contractual relationship. And then you really do need to look at the terms and make sure you're also being compensated for the issues that the vagueness can bring. So overall, I would say it definitely depends on the brand, but for the most part, they're pretty vague in terms of what they want from you.
And I think just starting early in terms of managing expectations between brands and creators, I think no matter who you're advising, if you're advising the brand or you're advising the creator, I think it's to be really clear as to when is something delivered. Because on the brand side, you might say, look, until or unless the content meets these specific deliverables, like it must be in this particular style, it must contain these particular references, it must be shot in this way, then it's clear for you, you're sort of protected from a brand side of this isn't what we asked for, or it is. And then on the creator side as well, I think it's important to not only be clear on what the deliverables are, but also be clear on the limits of revisions that you can make. I think what a lot of creators often get stung by is they produce something, they give it to the brand says, oh, could you just change this? And could you just change that? Now they spent more time than maybe the contract was worth actually making changes that weren't originally communicated. So on both sides, it's really important to be clear on when is this done? Because just borrowing from other commercial contexts, if you've placed a supply order with me and I'm required to supply you, 3 pallets of a certain fabric and I don't supply it, or it comes and it's clearly defective, I think we've got lots of established statute and authority as to when a good's properly delivered, when is there a right to refuse them. But in this creator economy world, it's very vague. So building on the vagueness when it comes to deliverables, just going back to the structure of these agreements, you mentioned that in general they can be quite vague. What about formality? Is it common because we know you can reach an agreement orally, it doesn't have to always be written down, but would you say that there is an industrial issue with informal contracts in the creator economy?
Yes, and I think it also reflects how both the creator and the brand see these collaborations as, informal, especially from a creator perspective. You aren't trying to be like so inundated with like 50 clauses. Like you just want focus. You want to be able to focus on creating really cool things. So you're not so bogged down on the details. But in reality, the devil is in the details. And that is how a lot of people get tricked out of things. So I would say the contracts tend to be pretty simplistic. And that's why a lot of them don't cover, how many revisions are appropriate, or how long content is going to be used for, or, in what context can they use your content as well. And those are where the real issues come in. So I think the contracts tend to be overly simplistic and should really list out and define all of those different terms. But I think creators don't care for it. They just want to make their money.
I mean, you want your creative flow. So for obviously, like we've mentioned, a lot of creators, they don't want to get bogged down in the details. And I think this is where creator agencies can come in. But this is where you need to be aware, almost doubly aware, because you need to be aware of what you're agreeing with the brand, but the agency has also got a contractual relationship with you as well. So they, under agency agreements, will have the authority to act as your agent. So they will be able to negotiate on your behalf, enter into agreements on your behalf, but they will also most often receive payments on your behalf and also collect fees out of what you receive also on your behalf. So when you're thinking about it let's talk from the creator side first of all. yes, an agency, or maybe you can say, what are some of the pros of being under an agency? But then also just bearing in mind this thing about not wanting to get caught down in the detail. What can some of the cons be with going under an agency?
Yes, I can definitely speak about this, having been on, I guess, both sides, so self-managing and also with various agencies. I think the pros of the agencies is that they will be your advocate. So from a business perspective, they will be able to, as you said, negotiate the highest rates. They'll be able to pitch you for brands, and they'll be able to manage those details that as a creator, you don't really want to get involved in. So that's a really, really big benefit. And they can also just help develop you in terms of your career and think of cool ideas for you. They'll be invested in like the metrics and all the things that as a really big creator, you just don't want to get involved in because you want to focus on being in your creative flow state. However, the cons of the agencies, I think, are number one, transparency. I was at like a creator event. It was for like a startup that was basically helping creators get paid their invoices ahead of, so they don't have to chase the brand essentially. And I remember one creator saying that she was with an agency on I won't say which brand, but she was on a campaign. And let's say the agency told her, okay, you're going to get paid 500 from it. And then we're going to take 400 or 20%. So 100. But when she spoke to another creator, she realized, oh, this brand actually has a fixed fee and they're paying everyone 1K. So her agency essentially lied to her, lowballed her so they could take more. So the agency at the end would get 600 and she would get 400. And the only reason she knew is because she spoke to another creator who happened to be on the same campaign. And I think the issue that you can have with some agencies is they're a business at the end of the day. They're also invested in making money. And some of them don't operate with that level of transparency. And as a creator, if you're not that invested or you don't care for the details, that doesn't always serve you well. So I would say that's like a very, very big con. But I would say to any creator, they should always be invested in those details, because even if you are working with an agency, why would you want to outsource your whole career to a third party who has their own business needs? And you're just one of the many creators that they're going to work with. So that's what I say on that.
And, thinking as well from the perspective of advising creators, there's a few things that you need to be aware of with agency contracts, including the notice periods to end the agency relationship, introduction, any terms in relation to clients introduced to you under the agency. There can be certain contractual situations where the agency will still require payment of anything that you earn through clients or brands that they introduced you to in the first place. So getting involved with an agency can have much longer term repercussions than what a creator may initially consider. And when you are in the perspective of advising a creator, whether this is pre-contractual signing or maybe post-contractual, things haven't gone right, as well as understanding what agreements were reached with the actual brands themselves, it's really important to understand what situation was the creator in with their agency. Because we shouldn't just assume that the agent just has the relationship is just for the period of time when the contract is live. I borrow an example from the landlord and tenant example. I've worked on quite a few cases in relation to landlords and agents commission. So what may happen is a landlord may use an agent to put tenants in, and the agency will require a fee of every subsequent renewal, so long as those tenants originally introduced by the agency remain in the property. So you may have a situation where the landlord is no longer using those agents. Maybe they're happy, they've got some tenants in their property, they're just dealing directly with the tenants. The agents will still enforce the renewal commission, because they'll say, for every renewal of the tenancy with the tenants that we gave you, we want a percentage fee. So those of us advising in the landlord and tenant context, we've come across this. But it's interesting to note that similar things can actually happen in the creator context as well. Okay, so having talked about the structure of how creators actually end up working with brands and the relevance of the agency context, I thought we could talk about another common area of risk in creator contracts, and that is misunderstanding when content is legally an ad or an advertisement. So many creators and brands incorrectly assume that if a creator's got creative freedom, or if a post seems quite informal, just like a story shout out or something like that, then it's not an ad. But in reality, the legal tests and the relevant legal principles are much stricter, and they often catch people by surprise. So what's at the heart of this is the fact that both creators and brands are responsible for non-compliant advertising, regardless of who drafted the caption or who pressed publish. So when it comes to UK advertising law, the relevant pieces of regulation, we've got the CAP code, which is the UK Code of Non-Broadcast Advertising and Direct and Promotional Marketing. And you also have the Advertising Standards Authority, or the ASA, who actually enforce the CAP code. When it comes to when the CAP code is applicable, so this is where a creator has received payment or other reciprocal benefit, and the brand has exercised any level of control over the content. So when it comes to things like what actually is an advert under UK law, I think it's important for people to be aware that even if you've been gifted something by a brand and the brand has asked you, could you post a story for us? And then you've posted the story from the brand then reposts that, or they take that video and post it on their own platforms. As far as what the CAP code is concerned with, you have received a reciprocal benefit. And on the brand's perspective, they're in control. They've exercised some degree of control because they've asked you to post, they've told you what they want you to post about, and they've told you how they want you to post it. So both parties are captured. What I thought would be interesting to talk about, because I know this is probably going to catch people out, is about payment, gifting, affiliate links, trips, and commission. So this all falls under the head of payment, doesn't it?
Yeah.
And maybe from either perspective that you feel you can speak from, why do people often underestimate gifting, affiliate links, or trips and things like that as forms of payment?
No, that's a really good question. And I think it's because, as we said earlier, the formal campaigns or ambassadorships are quite vague in general, even though those are the ones that are the most, will have like direct implications on you as a creator in a very long-term way, even if it's just the 3 weeks you're working on the campaign or the year you're an ambassador. But I think with gifting, because it happens much more frequently, it might happen through a third-party agency that has, you've never spoken to that makeup brand or that, that travel agency before, but they've gone through a third party. So because of how informal they are, and it's really just as simple as, hey, we want to send you products, please send us your address or your PO box. That's why. So I think when creators receive it, it's just like, oh, thank you so much for this. Or, oh, guys, I was really liking to use this, lip product. So I think it's because of just how informal the nature of those things can be. However, even from a tax perspective, when you do receive gifts and trips, it's seen as, I think the terminology is like payment in kind or something like that. So, oh, thank God, my in-laws coming back. But those things also have tax implications. So if it has tax implications, then surely that it has legal implications. So I think it goes to how informal these things can be. But I think to an extent, we need the industry to become slightly more formalized, because it's an economy that's worth literally billions. And most of the time, it's the influencer that gets the letter from HMRC saying, what are you doing? Or they get, a warning from the ASA.
Yeah, so when it comes to ASA's compliance or the CAP code, so it's both the creators and brands, like we mentioned, that are liable for breaches. It can require the removal or the amendment of content, including any disclaimers, and persistent non-compliance can lead to placement on the ASA non-compliant influencer list. So there are a few interesting people. I'm pretty sure there's a few reality TV stars that have made their way there. And there can also be referral to trading standards as well. So effectively, the point to take away here from a practical perspective, if you're advising clients or if you are a creator or a brand, is that you cannot avoid liability by outsourcing to agencies or creators. So as a creator, you cannot just defer to your agency and say, well, they didn't tell me, it's your responsibility. And similarly for the brand, you can't say, oh, we hired an influencer marketing agency. There's a case where there was an influencer who got in trouble for promoting baby formula. She was a mumfluencer, and she posted links on her stories, but she hadn't disclosed that she was part of the affiliate scheme. The brand itself, it was either Sainsbury's or it was a baby formula brand. I can't remember right now. But the brand themselves tried to say, well, we never directly engaged her as an influencer. She joined an affiliate scheme and got an affiliate link through there. But the principal point was that you gave your authority to the affiliate scheme to procure influencers for you, and you set terms that the influencer had to agree to. So if there were things that were non-compliant about the influencer's advertising, both you and the influencer are liable. So I think it's important for everyone to be aware that you cannot escape liability by delegating to a third party, as is quite common, like you said, when it comes to this. So just in terms of a bit of law, the Digital Markets Competition and Consumers Act 2024 sets out various relevant provisions as far as it affects influencer marketing. Particularly, you have Section 225, which is the prohibition of unfair commercial practices. This defines a commercial practice as an act or omission by a trader relating to the promotion or supply of the trader's product to a consumer, another trader's product to a consumer, or a consumer's product to the trader or another person. The definition of consumer is an individual acting for purposes that are wholly or mainly outside the individual's business. And trader means a person acting for purposes relating to a person's business, or a person acting in the name of or on behalf of that person, aka P, for the purposes relating to P's business. So when it comes to what is an unfair commercial practice, and let's just think about influencers and things that we may have seen on social media. So a commercial practice is unfair if it's likely to cause the average consumer to take a transactional decision that the consumer would not have taken otherwise as a result of the practice involving one or more of the following. A misleading action, so that's defined in Section 226, a misleading omission, which is defined in Section 227, an aggressive practice, which is defined in Section 228, and there's also a contravention of the requirements of professional diligence, omission of material information from an invitation to purchase. And what I think is very interesting, it is listed in Schedule 20, commercial practices which are in all circumstances considered unfair. So just taking a few of the things that are in Schedule 20, so claiming to be a signatory to a code of conduct when the trader is not. I think that would be relevant, particularly in any regulated professional context. You know, if you're saying that I'm regulated by the Financial Standards Authority, you know, by my investing guide, that's a commercial practice that's in all the circumstances considered unfair. Things like falsely stating that a product will only be available for a limited time, or that it will only be available on particular terms for a limited time in order to elicit an immediate decision and deprive consumers of sufficient opportunity or time to make an informed choice. So if you as an influencer, you know, you want to just add a bit of spice to your content. So you say, okay, you have to get this by the weekend. There's going to be no more stock. Like if you don't buy this now, it's going out of stock. That would be considered unfair commercial practice. Using editorial content in the media to promote a product where a trader has paid for the promotion without making that clear in the content or by images or sounds clearly identifiable by the consumer. So frequently you might have brands, you know, maybe they paid for an endorsement, but they're posting it as if it's like an organic, spontaneous endorsement. Like, no, that was a paid promotion. You asked Michelle Obama to say she used your toothpaste. She didn't do that by choice. Something I thought that was really interesting, and I'm not going to say which brand it is or which founder it is, but I wonder if you can guess.
I know.
So Section 25 of Schedule 20, falsely claiming or creating the false impression that the trader is not acting for purposes relating to the trader's business or falsely representing oneself as a consumer. So I've definitely seen TikToks where someone's promoting clothes from their brand as if, hey guys, I just saw this really cool coat. Isn't this a great coat?
Like, you should get this coat.
You should really get this coat. And it's like, no, what you need to do is clearly disclose, this is my brand and I'm promoting a product from my brand. I think, especially with the rise of founder content, I really think that is something that people might unwittingly fall foul of, because you're probably thinking, well, what's the harm? You know, I'm an influencer. Sure, it's my jewelry brand, but what's that got to do with anything? It's like, you need to clearly disclose that this is your product, you know? And I was just wondering, at least in terms of your experience, do you think I think this is something that people are getting wrong quite often.
Yeah, they are. They're not only getting it wrong, they're actually getting in legal trouble. Like the influencer in question did get in legal trouble. And I think sometimes they want to plead the fifth, like, oh, I just didn't know. That doesn't cut it in the world of law, unfortunately. You not knowing doesn't mean that you didn't do it. So I think people just need to be a bit more transparent and honest about the nature of their relationship to any brands. It can be as simple as, guys, this is my favorite brand. I don't work with them yet. I would love to work with them. Please put them in the comments. Or, oh, guys, I've actually really been loving this, you know, this top from Urban Outfitters or whatever the case may be. And then you can put a hashtag ad so we know it's an ad. It's just a lack of transparency, but it takes just such a little change in order to be on the right side of things. So even if that influencer/founder put hashtag ad or I don't know, hashtag gifted, or this is just made it clear, like, this is my brand, that would have saved them a lot of the issues that they actually ended up having.
And they did get reprimanded by the ASA for that.
They did.
And I think just also in terms of compliance, there are tools now. Almost every social media platform makes it super easy for creators and brands as well to disclose, this is promoted content, this is brand content. So I think the key thing to summarize when it comes to compliance with the statutory and regulatory regime is that failure to comply is not just slap on the wrist, it actually can amount to a criminal offense. And like I've mentioned, enforcement powers sit with trading standards. So things can get very, very serious for you and your business. So advertising regulation and the whole business of influencer marketing shouldn't just be considered from the reputational risk perspective, but actually it should be considered just as formal regulatory territory as anything else, whether it's finance or law. And also there is a real risk of criminal exposure if things are that extreme. So let's get into what most people will think about when they think of creative agreements, and that's ownership of the content, intellectual property, and control. So one of the biggest misconceptions and sources of friction in creator contracts is a basic misunderstanding about who owns the creative content and what brands are actually entitled to do with it. Many collaborations proceed on the assumption that payment equals ownership, but in English law, that is rarely the case. What we'll do in this section is talk about how intellectual property rights arise in creator content and how they're transferred or licensed, and why vague drafting can create long-term exposure. So by default, let's talk about who owns the creator content. By default, by operation of law, the creator will own the content that they create. Isn't that right? And ownership is not the same thing as giving someone permission to use your content. So the key concepts here for practitioners or creators themselves is you have the ability to license your content. So like most licenses, it does not mean exclusive ownership. So taking it back to episode 1 with Anna Zandi, where we talked about licenses versus leases, the lack of exclusive possession is one of the distinct features of a license. And then similarly in the content context, the lack of exclusive ownership is the distinct feature of the license. Why is it that brands, and particularly I'm thinking as well, maybe startup brands that aren't that used to this, or they're new to influencer marketing, why is it that they often assume broader rights than they actually legally have?
That's a good question. I think brands assume that because it benefits them. Like if they believe that, okay, once we get this content, we can use it however we want, in their head, they know that whatever fee the influencer is quoting is really going to lowball them. And ultimately, brands get a lot of value from organic content. Even if it's like paid content, they still get a lot of value from that. And I think they bank on the fact that a lot of creators and even agencies don't know that much and don't have that much knowledge. So I think that brands and agencies really need to understand that seeing your biggest influencers promoting something on a long-term basis definitely does something to the psyche, and the brands recognize that. So again, by lowballing, they are able to just extract a lot of value, and that's why brands assume more ownership, because the creators and the agencies won't challenge it.
Yeah, because maybe they don't know.
Yeah.
So in terms of just the legal notes, point to take away, the key statute in relation to these types of intellectual property rights, the key piece of legislation for all creators to be aware of is the Copyright Designs and Patents Act 1988, or the CDPA. And that provides that copyright subsists automatically in literary works, artistic works, films, and sound recordings. So long as they're original, then your copyright will subsist automatically in them. Contrary to popular belief, you do not need to do anything further than be the original creator of the work in order to benefit from copyright protection. So when it comes to social media content, it will generally fall under either a film, an artistic work, or where appropriate, a sound recording. So what's important, the key principle to take away, is that copyright vests in the creator as the author of the work, unless it's lawfully transferred. So in terms of assignment of copyright, copyright is a property right. And on that basis, it means it can only be assigned in writing and when it's signed by or on behalf of the owner. So an agreement to collaborate or to be paid for original content does not in itself assign your copyright to the brand or whoever has entered into that agreement with you. So if a contract does not contain a valid written assignment of copyright, the creator remains the original copyright owner. So when it comes to licensing content, if content is still, the copyright is still owned by the creator, they haven't transferred ownership of their content, then what will happen is brands will typically rely on a license. So key contractual issues that everyone needs to be aware of, and I thought this would be a good opportunity to talk about exclusive licenses as well. So the scope of the license, so which platforms, formats, and specifically which campaigns does it extend to? What is the duration? Is it fixed term, or that scary word we lawyers hate, perpetual? Where is the territory that the license extends to? Is it just in the UK or is it worldwide? Many brands don't just operate in one country. So if I agree with L'Oreal that I will run a campaign based on, maybe they're doing a London-based campaign, this is an international global brand, can they then take that content and use it to promote maybe in China or in anywhere else in the world that they plan to promote? Or have we agreed something that's UK exclusive? And also key things that need to be in the contracts. What is the purpose? So is it for organic posts only? Is it for paid advertising? So can the brand run ads with your content? And how, if at all, can it be repurposed in future campaigns? So a common problem that occurs in practice is that licenses are drafted too broadly or not at all. So just in turning to your experience and also good practice, in your opinion, where did things tend to go wrong when it comes to the scope and the extent of licenses, when it comes to license to use content?
This is a very good question. I have personal stories I'll get into in a second, but I think it goes wrong in the vagueness and it goes wrong in just not talking about it. So there's a lot of assumption, maybe from the brand perspective. And especially because if it's an informal collaboration, like even it might be you doing, if you get gifted something and you do like a short story and they like screen record it and use it forever or for a very long time, it can have the same sort of implication as like you having worked on a campaign and then it's used, for ages. So it's just that informality, not discussing it. So something to really look for in the contract. And if it's not there, asking the brands directly, okay, what's the scope of this content? How long are you going to use it for? And if you're going to use it for X amount of time, or if you want ownership over it, my rate needs to reflect that. Because I think at the crux of the issues you've all discussed today, it's the rates not reflecting, and the rate is like how much people are paid. That is not reflecting the level of usage and ownership. I'll give you a very good example of my situation that happened to me a few years ago as well. So I was with an agency, managed by an agency, and a brand approached me for a campaign. They just wanted me to do a TikTok video to promote like a job they had for students, right? And it was when I was quite, I guess, early in my creator days, so I didn't even get paid that much, but it was still something. I was really happy. So it was an email exchange. And another issue is that the brand reached out to me through a third-party agency. That's going to be very important in the story. So I thought, okay, they said the content's going to go live on, let's say, like the 1st of September 2020 for a period of 4 weeks. And you have to give them a code on TikTok, essentially. And when you give them that code, they can boost it from like their brand page.
So that's when they promote. So let's say you make a video and then from their brand account, they'll run ads against that video.
Yes, yes. So that happened, all good. And as a creator, another really good thing about TikTok is if the brand wanted to use that beyond that period, they can't until you generate a new code.
Okay, good.
So naturally, my content didn't say that we were going to have it longer than that period, but they didn't care. So they just maybe screen recorded my video, took my video, and they were running that, I don't even mean for weeks, I mean for years.
Wow.
Running it as a Snapchat ad, they were running it as an Instagram ad, and I'm thinking, hold on.
That was not agreed.
Not agreed at all. I have friends sending to me like, oh my gosh, you're doing so well. And I said, girl, they need to take it down. It's not paid me.
Yeah.
So my agency began them fighting for me. But then the problem is that agency that had been hired by this company no longer worked with that brand. So we're like, we're not involved. And I was like, but hold on. You guys are.
So they acted on behalf of the brand.
Yeah.
And then the brand, once their relationship had ended, had continued to use that content.
Yes.
Wow.
And they were kind of like, it's not our problem. So then my agency reached out directly to that brand and they were just ignoring us. And the brand had even like changed its name. It was just so much drama. And to this day, was not paid more than the initial low amount. And it was used for a very long time. But I learned a lot from that in the way that the creator economy was, and still is to an extent, is there's a lot of like third parties and it can be really difficult to kind of see where all of the power lies, which is why, at least from a legal perspective, having everything in writing, very specific, is necessary, because it might not matter to you because you just want to get paid, your 3K, 4K, 5K, but it will matter once they start to use it crazy or once you're seeing it ran as an ad for years and years on end. So it's really important that you get into the details.
So from a advisory perspective for practitioners in this area, like we mentioned before, these are often quite layered relationships that we're looking at. We shouldn't just assume that it's direct B2B or creator to brand. Actually, there could be a lot of third parties and intermediaries involved, and there might be a lot of practical work for us to do to actually unpick who is responsible for what. But at the end of the day, as a creator, so long as you own your copyright, it's yours. Something that sits alongside your copyright are your moral rights. And this is also set out in the CDPA 1988. So creators also benefit from moral rights, which include the right to be identified as the author of their work, the right to object to derogatory treatment of their work. And key points here are that moral rights are distinct from your copyright. They cannot be assigned. They can be waived, but only expressly and in writing. So the practical issue for creators here is that they may feel that they're at risk at reputational harm, even where brands believe they have usage rights. So let's just take, for an example, you've collaborated with a brand that maybe at the time of when you collaborated with them, maybe they didn't offer a product that is off-brand to you. I'm thinking about the beauty space because I'm thinking about how many times beauty creators have collaborated with a brand. Remember back in the YouTube days, and then maybe the brand later on released a very or not inclusive collection, or the brand participated in certain activities and things like that maybe the creator themselves weren't aligned with. And despite maybe expressing to the brand, they no longer wish to continue to associate themselves, the brand has gone on to continue to use their content, or has adapted or modified their content to suit a particular narrative from the brand. The creator, unless they've expressly waived those rights, will always be able to enforce and say, look, I did not consent for my content to be used in this way. At the time when, I entered into this license with you or whatever, or I permitted you to use my content, I believed that your brand was this type of brand. I didn't know that you were actually that type of brand. So moral rights are important because you'll find, and something I'll talk about shortly in terms of AI, the rise of image generated content, and also deep fakes and everything like that, that maybe something that was innocent enough initially can actually be manipulated in ways that you didn't intend, and that can be quite dangerous. Briefly, just to talk about image rights and passing off, because this fits into the next thing I want to talk about. Whilst in the UK we don't recognize standalone image rights, misuse of someone's image could give rise to a passing off claim. So the very famous one in English intellectual property law is Rihanna with Topshop. Back in the day, I think they released a t-shirt with her face on. She didn't actually agree to that. And so she was successful in the passing off claim. It could also affect breach of confidence between the parties. So that could be a real big issue in terms of the ongoing business relationship. And it could give rise to other contractual complaints. So claims. So for example, if people have acted to their detriment on the as a result of manipulated media featuring your face or your likeness, you may also want to pursue a claim against the brand because people are pursuing you. So there can be a chain of issues. So when it comes to, just from your opinion, when it comes to editing or repurposing content, what control, if any, can a creator have to prevent their content being edited or repurposed in ways that they don't consent to?
Oh, that's a very good question. I think in terms of controls, it can be difficult, to be honest, because you don't always foresee how your content is going to be received or how the brand might think to use it. So I think the most amount of control they can have is over the creative process and thinking long term about how could this content be used in a way that goes against my rights or goes against what I stand for. And it's about really, I think, talking to your agency about that. Like, you might innocently create, I don't know, a day in the life. But if you know this brand is already one that has questionable morals, or they do things that don't necessarily align with you, it's just about really limiting the scope of that usage and also creating your content in a way that's maybe very campaign specific to avoid that. But it's really, really a slippery slope, and it's quite easy for it to be repurposed, honestly. So the most you can honestly do as a creator is just try to control that process.
And I think the stronger and more clear cut your contractual provisions are, at least you can, even if it's retrospective, you still have enforcement options open to you. So let's just run through some of the contract gaps that can often trigger disputes. I think we've talked about a lot of them already in terms of duration of use, scope of use, territory, platform creep. So maybe you've agreed for your post to be on one platform, and like in your experience, it's being posted everywhere. Something I think is a growing risk is translations, auto dubbing, subtitles, and localization. So what's included now in almost all social media platforms is the option for your content to be auto translated. So try it when you get home. And if any of you watching or listening also create content, have a look at your settings, particularly on Instagram. There is an option to allow your content to automatically be translated into other languages. So this means that anyone in the world, no matter what their native language is, will hear an auto-dubbed version of you in your own voice, fluently speaking that voice. So you could be promoting a beauty brand based in the United States or in the UK and speaking in English, but if you're not aware, there could be a version of you speaking perfect French, perfect Mandarin, perfect Hindi, whatever, all around the world, and you don't even know.
Wow.
And you have, and unless you are very clear as to, I only authorize my content to be used in exactly this format, you could find yourself, again, without knowing, in a contractual situation that you, or out of contract. Exclusivity clauses and undeclared competitor conflict.
Oh, child.
This is something that I think if you are advising, particularly a creator with a very big brand, personal brand, and particularly where these are high value, a lot of brands will ask creators for exclusivity provisions, won't they? So I was wondering if you could briefly explain what that is and how that works in practice.
Yes, that's a very good question. So exclusivity is essentially when, if you work, as you said, with a big brand or even smaller brands, in that contract, they will say that for a duration of time, you cannot work with their competitors. This is because they kind of want your content to seem obviously organic, and they want to also make you seem most affiliated with their brand as opposed to their competitors. The problem with this is that exclusivity can be very long depending on what you negotiate. And that means that it could also stop you from making money from other brands that want to work with you. So if you're a beauty creator, you can imagine that if you work with MAC, them saying that you can't work with NYX or with L'Oreal or with Rimmel for 6 months is a long time. It can affect you as a creator in terms of the campaigns you can be on. So it's about making sure your rates reflect that, but it also doesn't necessarily tell the future. Because if you, for some reason, like even what we described earlier, if you have some sort of like disagreement with the brand or you don't want to be affiliated with them anymore and things like that, it can just be really difficult to work with other brands that actually align with you. So I would say to either really limit exclusivity to the length of the campaign or to a period as short as possible. And I think you'll probably find the most risk or challenge in doing that when you're on like a long-term ambassadorship. So those are like the issues with exclusivity.
Yeah, and I think Gymshark is one that's known for
Yeah.
being extremely strict.
Yeah.
You can't be associated with any of their competitors. I mean, makes sense because you do get there is a benefit. So there is a payoff for the creator, but again, it's something you really need to think about and be aware of and not fall foul of, because you could get yourself in some serious trouble. So you've mentioned, and we've talked throughout about basically exit strategies. So when creative collaborations go wrong, legal risk and reputational risk tend to escalate at the same time. So a single non-compliant post can trigger regulatory scrutiny, online backlash, and commercial fallout, all before lawyers are even consulted and get involved. So where things move quickly and publicly, as they do in the social space, I think it's good for contracts to have some provision to manage that risk. So one thing I was thinking about is, let's say a brand has worked with a creator, the creator goes through a scandal, something's going on, it's gone viral. In those circumstances, brands are going to want to disassociate themselves as quickly as possible. But do you think that enough thought is given to that when it comes to contractual negotiation?
That's such a good question. And I've never thought about that circumstance, even though it happens in real time a lot. I don't think people think about that. I don't think creator thinks about that. And I don't think the brand thinks about that. But the risk that can pose is when brands assume that they have more power than they do, and they see a creator that they have a campaign with live and they've not like paid them yet, they just think, well, you're a mess. We don't want any link. We're not going to pay you. We're not going to do this. We're not going to do that. That creator has essentially been cancelled or is in some sort of controversy, and they're probably feeling overwhelmed with everything. So chasing brands that no longer want to work with them for payments or for any other benefits that have been agreed, it's something that they're probably just not going to do or won't be at the forefront of their mind. But I think there does need to be provisions, both for the brands and also the talent, to say, in spite of any sort of
may have happened, we should still pay.
Basically, even though of course we don't,
and even if we do cease the relationship, whatever. So I guess so long as the creator hasn't fallen foul of any, for example, morality clauses, which are included, especially when it comes to ambassadorships, you are expected to behave in a certain way. So long as you've not fallen foul of anything like that, then it would be sensible to have provisions that, the parties can cut ties and have a clean break. But both parties are protected.
Yes.
I think that's important. Slightly onto another topic, but in the same area, is in relation to reputational risk as far as from a regulation perspective. I wanted to briefly touch on this because I know more and more creators, there's a rise of intellectualism online.
Informative intellectualism, but anyways.
But if you, like we are in a regulated sector in law, we're in the legal sector, that also extends to people working in finance or healthcare or anything like that. There is constantly a regulatory awareness we have to have about what we're actually saying online.
Yes.
And we also, for example, just can't be on the internet giving out legal advice or financial advice without clearly disclosing the relevant caveats, clearly disclosing that we are a regulated individual. And I think if it gets to the point where essentially you are, we're not allowed to solicit for work as barristers, but if effectively people are purchasing things from you or doing things on the basis of your advice, all of the regulatory requirements are in effect. And so I was wondering whether you share my concern that maybe some creators, especially, let's just call them professional content creators, in the sense of they've got a professional career. I feel like then they don't think about that so much because you do get a lot of feedback on social media. People love hearing when you're a lawyer or you're an accountant or you're a doctor, but actually the costs of those followers or that social media clout you can get can actually be your license.
Yes. And I think have the disclaimers like, this is not legal advice.
This is not legal advice.
Like, this is actually not legal advice. And I think it just takes being able to do that. And one thing that I think I can speak that I know TikTok does is you're giving out financial advice. Even if I just talk about student finance or something that has barely any link to money, even talking about like how much money to make, anything, they automatically have some sort of...
They flag it and say,
exactly,
make sure you get your own independent financial advice. Yeah.
Yes. And I think that needs to happen across professions. I think even in China, they've got like laws now that if you are a sort of professional, you need to like prove your credentials before you come online.
Yeah.
And it's just really important because you don't want to lose your license because you also want to create content. Even if content is like your end game, right? You still want to be able to be in good standing with whichever regulated body. So it's just a really simple disclaimer saying this is not financial advice, this is not legal advice. And also looking at the platform rules, because the platform rules can also guide you towards making sure you're compliant. Like at the end of the day, they want to have creators on the app, but they also don't want you to risk yourself or risk reputational.
And as well, if a brand wants you to do anything like that, it's your responsibility to say no. Because the brand, like we talked about, if something goes wrong and you end up cancelled, they're going to want to disassociate themselves from you immediately. But that's why you often won't find, or if you do find them doing it, it's heavily disclaimed. You won't find doctors promoting certain medicines or medical treatments. You won't find lawyers promoting, maybe if it's at least I'm thinking consumer facing legal applications, products or services. You won't find many of us doing that because we're aware. Financial people regulated by the FSA, they're not going to be out there promoting their crypto coin or their cryptocurrency or promoting a scheme or anything like that, because we know that we'll fall foul of our regulatory duties. And I think it's important, if you are considering becoming a creator, and you are from a professional services background, just really thinking about how much of your professional content you want to be part of at least your monetized content. And of course, I'll say that you are a great example of someone who does both very well and balances both very well. You're someone that I think is a really good example of balancing both those worlds and being able to share. I think you share as much as you're professionally comfortable to share. And you do have authority in the content you post, it's beauty and brains, but you talk about fashion, you talk about your nails, your hair, a beauty, all types of things that aren't necessarily directly related to your professional career. And I just wanted to point out that we need to be extremely careful, maybe more so than most creators would be. So going forward, we've mentioned, we've talked about manipulation of content or anything like that, but we are now in the AI era. Almost every single brand is using AI generated content somewhere in terms of what they're posting online. So what I wanted to talk about is, from a contractual drafting and negotiation perspective, do you think enough thought is being given to the new questions that have been raised around ownership, consent, and control in relation to the use of AI generated content? Are creators double, triple checking that whatever they send to the brands can now not be fed into any type of AI image generation system? Are they aware of, if they do assign over their copyright or they assign over the use of their content, what does the license extend to? I feel like this is all still quite fresh. And I don't think that it's something that maybe, especially from a practitioner perspective, we're as proactive about as I think as we should be. What do you think?
Yes, no, I agree. And I think it's because, as you said, it's an emerging space. The use cases aren't necessarily clear. Like, whilst we are seeing like AI influencers who may be using certain tones or phrases from certain creators that brands have worked with, it's still really an emerging space. But I think it's, again, just about making sure you understand the details of what you are agreeing. And if it's something you are concerned about because of the nature of your content, like if it's written content, for example, Just be really clear about that in your contract. At the end of the day, most, I think they're called GPTs, will have knowledge from all over the internet. So if I type in my name on ChatGPT, it's going to tell me these things about me, which is kind of scary. But just be aware that what you put out can be used by, even if it's not a brand you're working with directly, it can be used by another brand. So it's just about making sure that you define how comfortable you feel with that, and just think about the use cases for the content that you make.
And also, it may be something that seems innocuous, like they may be saying in terms of to edit the content or to clean it up or to do this and that, but it actually could end up being, changing what you're saying. They might say, oh, we ask for, we want this permission just so, in case we need to do some light edits, or, we can fix it up for you. I think you are the creator. It's your copyrights, your original work. Maintain as much control as you can over it, I think, is a key thing for creators to bear in mind. But just quickly on the brand perspective, a lot of brands are perfectly happy to be scraped by the AI tools, because they are then promoted in people's results. So the brand maybe has quite a large incentive for it, but you as a creator may want to think about that. So wrapping up then, everything that we've discussed from IP ownership to AI risk comes back to the same issue. Creator contracts are often treated as secondary operational documents when actually they are primary risk allocation tools. And if listeners take away nothing else from this episode, it's this: brand collaborations and creative collaborations are not low-risk marketing exercises. Contracts should allocate risk clearly and not vaguely. And creators and brands both need to slow down at the contracting stage and make sure that everything from ownership, use, and regulatory duties have all been provided for, and that the parties are extremely clear as to what they'll get out of it, and what their rights of enforcement are. So wrapping up, Mary-Grace, what do you think one contractual issue is that creators should always push back on, and one thing that brands should also make sure is tightened for them? Where's one for each?
Yes, that's a good question. I would say for creators, scope. Be very clear about the scope you're comfortable with and make sure your contract reflects that. I'll just leave it at that. For brands, I think deliverables, actually. I think if they're able to manage their expectations and have a level of control over the pace and the timing of the creative process, they'll be happy, they'll get what they want in good timing, and the creator will also be happy. And ultimately, they'll both be able to have that long-term relationship that they're looking for, which makes the content worth creating for both parties.
Oh, thank you. And thank you so much for being such a fantastic guest, Barry.
Girl.
I know that for anyone listening, it is absolutely a rare treat to get to speak to someone like yourself who's had really good experience on both sides of the fence. And I really hope that this is a valuable and informative episode for everyone listening. So thank you again for coming along.
Of course, no worries at all.
So that brings us to the end of this episode of The Ground Floor. A huge thank you to Mary-Grace Olu for joining me and unpacking the legal realities behind brand and creator collaborations and influencer marketing. If you are a creator, a brand, or advising either, remember that creativity does not remove legal risk. It often increases it. I'm Blessing Park, and this is The Ground Floor. Stay tuned for the next episode, where we'll be talking about recent developments in the law of digital assets and why the law now recognizes them within a new third category of property. I'll see you in that episode.